public defender, who don't believe such a conflict exists, makes this waiver in avoidance of being challenged.
Thank you very much.
Good morning, Your Honor. Intern Malika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender, Lauren Brown.
Permission to practice is granted.
Thank you, Your Honor. We do not believe there is any conflict between this honorable court and our office, and if any conflict is to arise, we waive that conflict so that this honorable court can hear these matters.
Thank you. And the court, for its part, also does not believe there's a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the cases of the people of the state of Michigan versus Christopher Nutley.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Nunley. Mr. Nunley, will you please state your name for the record?
Christopher Nunley.
Thank you, sir.
Your Honor, we are asking that these matters be set for a preliminary exam.
All right, all discoveries complete.
Yes, Judge.
People have their witnesses available to 12.
That's fine.
All right.
Judge, is that enough time? I'm sorry, for a writ to be done? He is,
Oh, he is. Yeah.
Yeah,
Jackson.
The 19th.
Preliminary examination in person, August 19, 2025, 9 a.m. That is before. Actually, it's at 12 p.m. before me.
Thank you, Judge.
Thank you, Bond. We'll continue. Okay. Let's call the case of the people versus Jacqueline Jones, Washington.
Andrew Childers appearing on behalf of the people.
Malika Fatima appearing on behalf of Jacqueline Jones, Washington.
Washington, Jones, can you state your name, please?
Jacqueline Jones, Washington.
Thank you.
Has the court received the report, competency report?
Is this a competency? Yes. All right. I have the report finding that the defendant is not competent to stand trial.
Yes,
that
we've
the
sent an
only-
order.
Pardon?
We've sent an order finding her incompetent.
Is there any other evidence?
On behalf of the people, Your Honor. The report does says incompetent but likely to regain competency in the South.
Say that last part again.
I believe the report references the CFP is seeking time for treatment and they miss Jones, Washington can be restored.
They didn't put that in the front of the report.
At the end of the report.
I'm sorry.
It's at the end of the report.
Yes, okay, I see it. Very last one. I see it. She can be restored in the statutory time frame. All right. You said you sent orders in.
Yes, we have.
I do not have them, but what I will indicate is we will set a competency hearing on this deal. I need 90.
October 23rd.
Set a review in this matter, October 23rd, 2025. 9 a.m. Bond will continue.
We need an order
Oh,
by case only.
Your Honor, if I may,
We need an order on the 2025 case only.
Yeah, because it was separated from the other ones.
Got it.
That's-
was there an order sent back in May, I thought? The court doesn't have that?
Which order are you talking about? The order on the findings? Not the finding, but we need the. Ms. Wilding,
I'm sorry, the 2025 case, there was an issue with the timing of it, so. the
Correct.
2025 case was rescinded. That's the one that needs the order.
Okay. So, okay,
Got it.
good, okay.
got it?
So
Yeah,
it's the
sure.
25 case that needs an order.
Yes.
Okay.
Thank you. Court does call the case. People versus Madden Delaney.
Andrew Dan.
Your Honor, good morning, Joe Simon on behalf of Mr. Delaney.
Madam Delaney.
Go ahead, sir.
Your Honor, I made a proposal to Mr. Banis. Mr. Banis wants to have the opportunity to talk to the officers about the proposal I made. Wasn't able to make that happen by today. So where the parties are requesting an adjournment of the PCC.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. or as your invite indicates, bond continued.
Thank you, Your Honor.
Thank you. Thank you. Court does call the case People versus Keandre Allen.
Families on behalf of the people, Your Honor.
Robert J. Coe on behalf of Mr. Allen.
Your name, sir?
Keandre Allen. Judge, I saw Keandre last night. He wants to proceed to exam. We have the discovery.
Your Honor, have to address bond when appropriate.
All right. You said discovery is complete, Mr. Philip.
Yes, you're on 99% of it. We will get the phone calls this week.
People have their witnesses available to 12.
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m.
Judge,
That's before.
I'm sorry, I didn't mean to interrupt, but I have a circuit court trial starting on the 11th. Can we bump it past that?
August 19th, 2025. That's at 9. At 9 a.m. before Judge Moore. As to bond.
Your Honor, it's my intention that since you've been arraigned, I haven't had a chance to listen to all the calls. I have 7 calls from victims. One of the calls I know for sure. The victims listed on my report, and he mentioned his kind of contempt for Judge Washington's court. After arraignment. So this time I'll be asking just one for the police for your vote.
Any response?
Judge, I spoke to my client last night. Assured me he has not made any calls. I would just ask you to allow him to
That
continue.
he's not made any calls?
Correct, is that correct?
Yeah.
Not, pardon me?
Correct. Right.
Not to the victim, Your Honor. There's obviously been phone calls, but not to the victim.
Okay, were phone calls made to the victim's number?
No, Your Honor.
Our numbers restricted.
You're saying they were?
I have phone
They're
calls.
restricted on mine.
And he mentions his hold on Judge Washington's court.
So do you want me to listen to that? Because if I do, then not only would I revoke his phone privileges, but I will revoke his bond. And I find out
Judge,
what he's telling me not to be the case.
Just cancel the phone calls for now, Judge.
Defendant's phone privileges are hereby revoked, and I've signed that order. Bond in all other respects will continue. Thank you.
Thank you, Judge.
Court does call the case of the People versus Conrad Neary.
Good morning, Your Honor. Victoria Burton here, Assistant Prosecutor here on behalf of the people.
Your Honor, good morning again. Joe Simon on behalf of Mr. Neary. State your name, Conrad.
Conrad Neary.
You don't have to wait. Just step up, half step forward.
All right, go ahead.
We've reached a resolution, Your Honor. You should have both a plea sheet and an executed advice of rights form.
I do. Plea form indicates that the defendant will be pleading to an added count 3 of use of cocaine, 1-year offense. Upon a successful plea to that charge, counts 1 and 2 in this case will be dismissed. He's also agrees to plead guilty under 7411 and continued compliance with his recommended treatment as part of this agreement. Also, there is the prosecutor will recommend no upfront jail so long as continued compliance with recommended treatment while on probation. That's the court's full understanding of the agreement.
That's ours as well, Your Honor. Mr. Neary filled out an advice of rights form. He's ready to answer your inquiries, and I'm pretty sure the matter's remanded to Your Honor, which is why there's no sentencing judge waiver on it.
That is correct.
Thank you.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Conrad Neary.
He's pleading guilty. Is
Yes.
that correct? Okay, because I have a report. All right. Sir, it is this court's understanding that you are pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay, yes, yes.
You
I
understand that?
understand, I understand.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
To
another court. You're not on.
no, I'm not. No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty?
Yes, Your Honor.
December 9th, 2024, at I-94 near South State Street in Pittsfield Township, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes.
Had you used it?
It was for your personal use.
Yeah, it was for my personal use.
Okay, and you knew what you had was cocaine, is that correct?
Yes.
All right, sir, I do have to advise you that if between the time of my taking your plea and accepting your plea, you come in court rules between this time and the time of sentencing, that first of all, you would not be permitted to withdraw your plea. You understand that?
I understand.
And you also understand that the court would no longer be bound by any type of agreement or evaluation of your case.
Yes.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Defense is not.
No.
She was concentrating. And have I complied with the court rule and would it be proper to accept this defendant's plea?
So satisfied.
Yes, Your Honor.
All right, court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
August 27th at 12 p.m.
August 27, 2005, 12 noon. Before me.
Thank you, Your Honor.
Thank you. Bond continue.
Thank you, Your Honor. Wait with your mom right out front.
Court calls the cases of the people versus Todd Rayberg.
Send in for Jay. Yeah. Oh, man, sorry. Yeah. Easy. I didn't know. You already do. Okay. I'm not.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Rayburn.
Kyle Burrell with and on behalf of Mr. Rayberg in the case ending in 0891.
Assistant Public Defender Jay Bellinger on all cases not ending in 0891, Your Honor.
All right. Your Honor, so Mr. Rayberg has a number of other matters pending. So at this time, we are asking for an adjournment to allow everything to sort of catch up.
Yes, Your Honor, we have all the orders signed for his cases today. I understand there may be some cases pending, but as of today, we are just waiting on a bed availability for him.
All right, so you're asking for an adjournment also?
An adjournment also, Your Honor.
All right. You're looking for at least 3 weeks? Is that?
Yes, Your Honor.
All right. Probable cause conference in these will be adjourned to August 19th, 2025, 9 a.m. All right, that's a Tuesday, just short of the 3-week time frame.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case of the people versus Seth Priester.
Okay, originally, the people on this and on this case as well.
Good morning, Your Honor. Wendy Barnwell, P42-505, on behalf of Mr. Seth Priester.
And Judge, not that anyone asked, but I'm the co-defendant's attorney, Mr. Henning. Just in case I'm needed, I'm here. Good morning.
You kind of snuck up there.
I did, yeah. A little shorter today.
How come you didn't do something? No, it was a threat to me.
Definitely a threat.
Do we have it?
We don't have the defendant.
Well, what are we doing on Mr. Priester's case? And the other case, I guess we'll bring him out, but
Well, with regards to my case, I think Mr. Priester's case, I think we were ready to set for exam.
We were requesting an examination.
all right. Is everybody going to be ready to go on the 12th?
The 12th is okay. That works with Ms. Barnwell.
One
What
split
day?
second, Judge. One split
Why
second. I'm
does,
trying
why
to.
does, when this case is called, it takes so long? Not looking at who might be the problem. No. No, it's okay.
I guess.
Okay. You said the 12th, one split second. Oh. What do you know? The 12th is available. I'm available on the 12th. Thank you. So happy.
So in the Priester matter, until Mr. Henning gets out here, preliminary examination in this matter will be in person. It will be set August 12th, 2025, 9 a.m. That is before Judge Freshour. Bond will continue. And hold on one more. Who do we have? You have Henning? Court calls the case of the People versus Henning.
And Christina Costantino on behalf of Mr. Henning, if I didn't already put that appearance on. Mr. Henning.
Sir.
Devasseer Henning.
Thank you. All right, and in this matter, your house, you have indicated requesting a preliminary examination, discovery is complete.
Yes, Judge. That
People could have their witnesses available on that date. I can set preliminary examination in this matter for August 12th, 2025, 9 a.m. That is before Judge Freshour. Bond will continue. Thank you.
Thank you, Judge. Would the court perhaps hear just a very brief bond argument? I'm just asking for a
Yes,
10%
on 200
provision.
cases I have today. Go ahead. I'd love to hear it. Go
I'm
ahead.
sorry, Judge. We're just asking if the court would at all consider a 10% provision of Mr. Henning's bond. He is obviously unable to post the bond where it's currently set. He has been incarcerated now for about 3 months. He has made the very most of his time incarcerated that he could. He's completed his GED at the Washtenaw County Jail, which is not a small feat by any means. He did that within the quickest time that it's even possible to do that. He very much wants to use his new GED to obtain employment upon release. He has wonderful family support. His family's present in the courtroom. They've been present at all court dates. I know that they'll be present in his life if he is to be released. We would ask if the court would consider a 10% provision in his bond.
Response. What was the weapon?
Firearm.
I'm gonna let what I'm gonna do at this time is I'm not gonna give it 10% provision. I think is, well, that would be 25,000. I presume, Ms. Barnwell, you're also making the.
Yes,
that same-
Judge. Yes, Judge. My client is, he's been very compliant while he's being placed at the juvenile facility in the compound there. His mother wants a tether, and I think that would be appropriate.
His bond is set at $250,000 at your client, Ms. Barnwell. Can I have that file back?
Yeah, that is excessive, Judge. I know that this court is aware of the presumption of innocence. And that it's not just a phrase.
Really? I didn't know. In both of these cases, I'm going to modify their bonds, there is a provision that if they're released, they are to go on tether, that will remain in effect. I will reduce the bond to 20 or 250,000. I'll give a 10% privilege on that.
And Judge, my client's bond, I believe, was 100,000. It was originally set at, or maybe it was originally set at 250, but it was at 100,000.
What do you have as bond? Well, what I'll do is if it's 100,000, I'm not gonna get the 10% privilege on the 100,000. I'll give it on the 250,000.
Okay, Judge. Yes, we would appreciate that. Thank you.
All right, thank you.
Thank you.
The court does call the case People versus Sherry Walker.
Yes, Your Honor, please do not report Brandon Bird on behalf of Sherry Walker.
Sherry Ann Walker. What are we doing?
I'm just asking, you should have an adjournment.
I do. All right. Probable cause conference in this matter will be adjourned August 14th, 2025, 9 a.m. On continue.
Thank you. You and Your Honor, court have a great day.
Court calls case of the People versus Mary Collins.
Calvert, on behalf of Mary Collins, who's at the podium.